my camera is on.
Okay, go ahead.
My name is Sanusi.
So it's my own. It is showing. Your own is showing.
Brother, I'm here with my learned friend,
Yes.
Uwem Eko.
UM Echo.
Uwem Eko.
Echo.
Eko. E-K-O-P.
Okay.
And Marcus Oguji.
And Marcus Eguji.
Yes, my lord. My lord will appear for the claimant applicant.
Okay. This matter is for ruling. The ruling is ready. It will be read now.
As the court pleases.
This deal with a motion on notice dated 22nd day of June 2021 and filed on the same day. The motion was brought pursuant to Order 17 Rule 1 of the National Industrial Code Civil Procedure Rules 2017, Limitation Act of Nigeria, and under the inherent jurisdiction of the court. In the motion on notice, the applicant is praying for 1, an order dismissing stroke or striking out the instant suit for being grossly incompetent by virtue of the principle of statute of limitation and thereby constituting an abuse of court process, as same is vexatious, irritating, and annoying to the defendant applicant. 2, an order dismissing or striking out this suit because the court lacks competence and jurisdiction to entertain the suit on the grounds that the suit is bad. And 3, and for such other orders, this honorable court may deem fit to make in the circumstances. The grounds for the application are: 1, the claimant suit is founded and instituted on contract entered into by the parties on the 23rd day of October 1996. 2, the claimant seek relief, settlement among other claims against the defendant and the monetary claim for expenses incurred at the hospital between the period of 2012 and 2016 for an incident that occurred in January 2001, where he allegedly contacted acute and chronic carbon monoxide poisons with multiple conditions and pending kidney failure and pulmonary collapse. C, the 6-year period prescribed by the limitation law for bringing the claim under simple contract lapsed in 2007. D, the claimant instituted this action for relief and settlement as a result of the contact between him and the defendant on the 2nd day of November 2020, which is a period of 19 years after the relief and settlement occurred. E, that the filing of the instant suit constitute an abuse of court process and judicial processes of the instant suit is vexatious and annoying to the defendant applicant, and same should accordingly be dismissed. The motion on notice is supported by a 14 paragraphs affidavit sworn to by Vitalis Osage Amoji, a legal practitioner in the law firm of Abaya's Law Office, representing the defendant. The affidavit is a rehash of the grounds of objection. A written address was filed along with the motion on notice. Vitalis Osage Amoji Esquire counsel for the applicant in adumbration informed the court that he is relying on the depositions contained in the affidavit in support and adopt the written address as his argument. Counsel also informed the court that he has filed further and better affidavit and a written address as a reply on points of law. Counsel relied on the said further and better affidavit as a reply on point of law. In the written address, counsel formulated 2 issues for determination. 1, whether this honorable court is not seized of jurisdiction to entertain this suit, stem having been caught by the principle of statute of limitation and stem being statute bar. 2, whether this suit discloses any reasonable cause against the defendant or does not amount to an abuse of court process, which should accordingly be dismissed with punitive cost. In arguing issue 1, counsel for the defendant submitted that in determining issue of jurisdiction, recourse must be had to the writ of summons and the statement of claim before the court. It is also submitted that looking at the originating processes, that is to say the complaint, general form of complaint, statement of claim, and statement of oath, specifically paragraph 10, 12, 13, and 18 of the statement of claim, the complaint of the claimant is that the defendant deserted him and failed to take care of his medical needs in 2012 as a result of the alleged acute and chronic carbon monoxide poison, with multiple conditions and pending kidney failure and pulmonary collapse suffered in 2001, despite the demand of the claimant respondent counsel submitted in its course of action, which arose in 2001. Counsel also submitted that the applicable law enforced as at the time of the course of action is in 2001 is the limitation law of the Federation and River State limitation law. Counsel refers to section 16 of the law and submitted that an action in tort negligence, damages, and breach of duty, whether the duty exists by virtue of the contract or of the provisions made or under an enactment or independently of any contract or any such provisions where the damages claimed by the person for negligence, nuisance, or breach of duty consist and include damages in respect of personal injuries to the claimant or any other person shall not be brought in respect of any matter which arose more than 5 years after the date of course of action has arose. Counsel also submitted that an action filed outside limitation law is statute bar cannot be maintained. On this, counsel relied on the case of Unity Bank PLC versus Wadike 2009 for NWLR 1131 page 352. He also relied on the Texaco Incorporation versus SPDC. According to counsel for the defendant, in determining statute bar, the court has to take into consideration the date on which the wrongdoing the right of action took place, as it is from the date that from that date time begin to run. It is counsel submitted that from the originating processes, the course of action arose in January 2001. Therefore, this suit is statute bar. It is also submitted that without considering that if there is continuance of damage up to 2012, when the claimant was admitted at hospital, the matter is still statute barred because it was filed on the second day of November 2020, which exceeded 6 years. Counsel at the court to hold the case is statute barred. In support of this, counsel relied on Idigbe versus Esen. We also relied on Abola She and others versus Mesa, Chevron Nigeria Limited, and others. It is also submitted that time begins to run for the purpose of law from the date of course of action. According to the defendant, the claimant course of action is statute bar because it arose in 2001 in respect of a contract that was entered into between the parties in October 1996. Counsel urged the court to hold that this case is statute bar. On issue 2, counsel submitted that this suit did not disclose reasonable course of action. Did not disclose reasonable course of action against the defendant. In arguing this issue, counsel submitted that the statute of limitation removes the right of action and leaves the plaintiff with a bare, empty course of action which cannot be imposed. It also submitted that the case of the claimant does not fall within the recognized exception to the limitation law, that ordinance constitutes disability of the plaintiff or admission or acknowledgement of liability in cases of negotiation between parties to a dispute. In support of this argument, counsel relied on the case of Arowolo versus Ijabi and the case of Iwoso versus Ofo. He also relied on Akiloe versus military administration of Ondo State. Counsel argued that the period of limitation cannot be extended by the court because it is a statutory provision. In conclusion, counsel urged the court on the authority of Elabanjo versus Daudi to dismiss this case from being started. A reaction to the defendant motion on notice, the claimant filed a 32 paragraphs count, which is a reproduction of some part of the statement of claim already before the court. The claimant of the counter affidavit has denied the claim of the defendant that this action is started by. A written address was also filed along with the counter affidavit. Linus Umbe Esquire, counsel for the claimant in adumbration, has informed this court that he is relying on the abatement contained in the counter affidavit and adopted the written address as his argument in opposition to the motion on notice.
Before they release a chemical. He's reading all these articles. When you say, I will not take arguments of counsel, arguments are on record. Let me go to my determination of the issue. Yes, the quality of ritual and all that. It's not talking now. is to yourself with all peace, you'll be happy. You don't even understand the issue. Why is it against you? You still will not give it out because it was not even given the food. It's just taking arguments of country. At the end,
if the admin can hear everyone, or can if the admin is listening on proceedings, kindly inform my lord that he's muted and so we cannot hear him. I believe whoever the NICN host is can hear me and should be able to rectify this. Thank you very much.
The judge is not muted unless you have fault with your device. The person who spoke, the court is not muted. The court is not muted. I hope you can hear me.
We can hear you now. But
I can hear you. I can hear you. But we could not hear you.
Well, from my own device, I was not muted. So maybe there is a fault somewhere along the line. I continue with the reading of the ruling. According to Council, paragraph 13, 16, 17, 24, and 25 of the statement of fact have shown the actual date of accrual of course of action, which are not 2001 and 2012. The defendant claimed Council submitted course of action consists of every fact which would be necessary for the plaintiff to prove its case if traversed in order to support his right to judgment. On this, Council relied on the case of Kado Trading Company Limited versus Abere, and also relied on Afolayan versus Oguride, and the case of SPDC Nigeria Limited versus XBM Limited. It is submitted for the purpose of limitation begin to run when the cause of action arose. Council relied on Aurolo versus Fabi Sufra and urged the court to hold that the claimant suit is not statute bar. On issue 2, whether claimant is entitled to an exception available to him under the limitation law to bring this present action in the event that the court holds that the action is statute bar. It is submitted that if this court holds that the cause of action is in 2001 or 2012, issue 2 will cure the defect. According to Council, without considering that this suit was filed outside the limitation law, the claimant's action is covered by exception under the limitation law. It is submitted from the facts of this case that the claimant was diagnosed with occupational case of acute chronic carbon monoxide poison with multiple conditions and pending kidney malfunction and pulmonary collapse. The claimant was subsequently flown abroad for treatment from October 2012 to July 2016. The claimant being away for medical treatment amount his ability to support this view. Council relied on the case of Stobin by web. It is also submitted having regard to paragraphs 4, 9, 10, 11, 12, 18, and 35 of the statement of claim. The fact that gave rise to this action occurred partly in Akwa Ibom State and partly in Rivers State. This means the applicable law are the limitation laws of Akwa Ibom and Rivers State. Therefore, by section 24 of the Akwa Ibom limitation law, Akwa Ibom State, which provide, subject to the following provisions of this section, if on the date when the right of action accrues or which a period of limitation is prescribed by this law, the person to whom it accrued was under a disability, the action may be brought at any time before the expiration of 5 years from the date when he ceased to be under the disability or dies, whichever event first occurred. Section 23 of the same limitation law of Akwa Ibom State also provide For purposes of this law, a person shall be under disability while he is an infant or of unsound mind. 23.2 said, stated that if this section, for the purpose of subsection 1 of this section, a person shall be conclusively to be of unsound mind while he is detained in persons of any enactment authorizing the detention of the person of unsound mind or criminal lunatic. It is the submission of counsel for the claimant that notwithstanding argument of the defendant on state of mind of the claimant, section 23, subsection 2 still protects the claimant as the claimant received treatment of mental health, which invariably affected his state of mind. Counsel also submitted that the evidence before the court shows that the claimant between 2012 and 2016 was at United States of America for medical treatment. If it is insisted that the claimant cause of action occurred in 2012, the claimant still excluded by limitation law period as provided by which it reads. Section 27 of the limitation law provides where a person is outside Nigeria when a cause of action accrues in his favor, the relevant period of limitation prescribed under this law shall not begin to run until he returns to Nigeria. And section 27.2 state the provisions of subsection 1 of this section shall not apply in case of a person who stays outside Nigeria, whose stay outside Nigeria is due to a flight from justice or self-imposed exile. It is the submission of counsel that there are certain situations in which application of the limitation law is curtailed, and an action which would otherwise be held to be statute bar will escape the hammer of the limitation law. In these types of situations, the limitation period will be frozen until after the continuance of damage or injury. On this, counsel relies on Idigbe versus Inandi. He also relied on Attorney General of Rivers State and Attorney General of Bayelsa State. He also relied on Obot versus SPDC and Gulf Oil Limited versus Olubo and Adepoju versus OK. According to counsel for the claimant, the defendant has employed several employees to deprive the claimant of his entitlement and medical expenses. The lawsuit is that party will not be allowed to take advantage of limitation law where there is clear evidence of disability, mistake, fraud, and in certain cases involve personal injury or death. In support of this submission, counsel relied on the case of Abubakar versus Milsilim Motor Service Limited, number 2 Shukra. In concluding his submission, counsel asked the court to dismiss the claimant preliminary objection for lacking in merit. The defendant's father and file a 20 paragraphs father and data affidavit and a written address, which reply on point of law. The response to the counter claim is in the area of abandonment to the fact that claimant is not consistent as he attempts to amend his claim changing date. Please, there should be no noise. This is court that is sitting, there should be no noise. The defendant also stated Exhibit C of the counter affidavit that the claimant has had health challenges for 10 years prior to the medical report of 2012. The defendant stated that the judgment reported as Mobile versus Johnson 2018, 14 Nigerian Kilo report, part 1639, page 329. The claimant was not a party to that suit and therefore cannot claim to take benefit of that suit. There is no evidence to show that the claimant was of unsound mind. In the written address, counsel also submitted that this action was commenced on the second day of November 2022 or 2020. Section 16 of the River State Limitation Law provides 5 years within which an action founded on contract like this should be brought. Counsel referred to several decisions of the Supreme Court and the Court of Appeal and that of this court to support the fact that the course of action, it is the claim that determines the course of action. It is also argued that the claimant have not shown or established that his case came within the exception to the statute of limitation. The claimant, having pleaded insanity, having not pleaded insanity, cannot rely on it. The counsel for the defendant also raised objection to the statement of claim and the counter affidavit, which he claimed were not signed by a known person or the person who signed was not disclosed. Counsel refers to several decisions of the Supreme Court and the Court of Appeal and submitted that the claimant's statement of claim is defective in that identity of person that signed was not disclosed. Counsel asked this court to strike out the suit for being incompetent. Court decision. I have carefully considered the motion on notice, raising the objection to the claimant suit on the ground that this suit is statute bar. A deep consideration of the entire processes before the court clearly shows that the defendant's motion on notice filed on the 22nd day of June 2020 is contesting the competency of this suit on the ground that it is caught by a statute of limitation and should be dismissed in limine. There is also a challenge to the competence of this suit raised in the reply in response to the counter affidavit and the written address filed along with it. The defendant is of the view that the statement of claim and counter affidavit were not initiated by due process of law, and this court is robbed of jurisdiction to entertain this suit. However, the claimant did not file any response to this new issue raised by the defendant. According to the counsel for the defendant, the statement of fact was not signed by a disclosed person on the process. I have scrutinized the originating process commencing this suit and the entire case file. It is clear to me that the defendant seems to misconstrue the essence of signing court processes by asking the court to confer signature on the statement of claim and that on the written address file along with the counter affidavit, and hold that the processes were not filed by a known or disclosed person. I have compared the signatures on the statement of claim and that of the address file along with the counter affidavit. What my finding shows is that the originating process was signed by Mr. George Jack, while that of the written address file along with the counter affidavit was filed by Mr. Linus Imbe. All of them counsel to the claimant. I am not aware of any law or rules of practice that make it mandatory for all processes to be filed in a suit that must be signed by only one counsel on behalf of the party. The process to be filed can be signed by any of the counsel, provided counsel has authority of the parties on whose behalf the processes is being filed. And there is no challenge to the fact that the counsel that signed the complaint or the counsel that signed the written address to the counter affidavit do not have the authority of the claimant to institute the action or file the said application on his behalf. The cases cited are relied by the claimant were not on all fours with the case at hand. Those cases deal with situations where the processes were signed by a law firm and not by counsel. In the case at hand, all the processes were signed by a non-counsel for the claimant. In the circumstances, I found no merit in the objection of the defendant on the competency of the originating court processes, and I therefore discountenance the said objection. I now turn to the main objection to the suit before the court. Let me begin by saying that the law is humble, where a statute prescribes a time limit within which an action should be commenced. Such legislation where the names of limitation is referred to as limitation law, as in this case, an action commenced after expiration of the period within which an action must be brought as stipulated in statute of limitation is not maintainable. The court would have no jurisdiction to entertain a statute-barred claim. Therefore, legal proceedings cannot be properly or validly instituted after the expiry of the prescribed limitation period. Thus, a cause of action is statute bar when no proceeding can be brought to impose it because the period laid down by the limitation law has expired by passage of time. See the case of Idigbe versus Ade Farasi. See also Nasir versus CSC Kano State. See also Kotekna International Limited versus Churchgate Nigeria Limited. See also the case of Ekiago versus Aliri. See also Udo and others versus Akwa Ibom State Government. It is pertinent to point out here that the aim and purpose of limitation law is to ginger up the aggrieved person to be vigilant and to discourage cruel actions and to preserve the evidence by which a defendant will defend the action. See the case of Aremo 2 versus Ade Kanye. See also the case of Olagunju versus Power Holding Company PLC. See also the case of Lafia Local Government versus Governor of Nasarawa State and the case of Solgrave Holding Incorporated versus FGN. A fortiori, the principle is well settled to the effect that where a plea of statute bar is raised at the trial of an action, as in the instant case, the crucial issue with reference to the crucial issue which the court must determine regarding this issue of statute bar is first and foremost to consider and determine is the determination of the date when the cause of action arose. To determine the date of accrual of cause of action, the case of Idigbe and Ade Farasi comes handy, where the Supreme Court made it clear it is by looking at the writ of summons and the statement of claim alleging when the wrong was committed, which gave the claimant a cause of action, and by comparing that date with the date on which the writ of summons was filed. This can be done without taking oral evidence from witnesses. If the time on the writ is beyond the period allowed by the limitation law, then the action is statute bar. For the meaning of cause of action, the Supreme Court, in the case of Akilu versus Power May number 2, has this to say: a cause of action has been held to mean every fact which is material to be proved to entitle the plaintiff to succeed, or all those things necessary to give a right to relief in law or equity. See Bello versus Attorney General of Oyo State. The period of limitation is therefore that period of time after the accrual of the cause of action during which legal proceeding can be brought by a competent party because the period laid down by the limitation law has not elapsed. Conversely, if the time limit comes within that period permitted by the law, then it is not statute bar. See the case of Ohere versus Emerua. See also the case of Aremo versus Ade Kanye Sufra. See also Ade Banjo, Ela Banjo versus Daudu Sufra. See also Williams versus Williams and Hassan versus Aliu. See also Tebo Green versus Governor of Delta State. A successful plea of limitation law will have two devastating effects on the action of the claimant. First, he becomes a destitute of the right of action and judicial relief. Put differently, it extinguishes his cause of action. See the case of Idigbe versus Ade Farasi. See also Nasir versus CSC Kano Sufra. See Abubakar versus Nasamu. And the second devastating effect is that the court ceases to be clothed with the requisite competence to entertain his action. See the case of Owena. See the case of owners of MB Arabella versus Naek. See also the case of JFS Investment Limited versus Browell Line Limited. See also the case of Bande versus Ogbuanya A plea that an action is started by is a defense. Therefore, the onus is on the defender raising it to establish by evidence his assertion that the claimant suit is started by proving the time the wrong complaint when the road was perpetrated and the time the claimant court case was commenced. The defendant has their application relied heavily on the federal limitation law and that of River State limitation law, while the claimant is of the view that the applicable limitation law are the limitation laws of Akwa Ibom and River State. Let me make it very clear here that the law gives the court unbridled license to apply any relevant legislation to any proceeding. Indeed, the law is in the breast of the judges, and he is entitled ex visto judicia to apply in deserving circumstances. See the case of Okochi versus Anemco. From the claimant's complaint and the statement of fact, the claim of the claimant can be categorized into two. That is to say, one, the claim for payment of unpaid salaries from October 1996, when the claimant joins the services of the dependent, to 13th day of July 2018, when the claimant's employment was purportedly terminated by the defendant. While the second set of claim is for refund of expenses incurred by the claimant on the medical treatment and sundry cost bills plus rents for treatment in Nigeria and in the United States of America. The facts that form the basis of this suit, as can be gleaned from the originating process, are that the claimant was employed by the defendant on the 23rd day of October 1996 into its security department at QI 80 Eket Akwa Ibom State. The defendant denied the claimant his correct status as its staff or employee, paying the claimant's stipends every month instead of remuneration contained in the dependent working agreement mutually negotiated by the claimant labor union. This led to the claimant, together with other members of his class, to institute an action for determination of the correct status of the claimant. The action was finally decided by the Supreme Court on the 20th day of April 2018. The case was reported as Mobil Oil Nigeria Producing Unlimited versus Okon Johnson and others, reported in 2018, 14 Nigerian Ukilolo report, FAT 1639, page 329, where the claimant and other members of his class were affirmed and declared to be employees of the defendant. As a punitive measure, according to the claimant, as a punitive measure for fulfilling the above, for filing the above suit, claimant together with others were in January 2001 transferred to Boni in River State to a very hazardous location of hydrocarbon gas plant of the defendant hydrocarbon gas plant in Boni Island, and they were deliberately denied the requisite and approved safety gears and personal protective equipment for such job or work location against the safety policy and the provisions and the requirement of occupational safety and health administration for industrial facility workers, which the defendant subscribed to despite their protest for non-provision of the proper PPE promised to deal with them. Sometimes in April 2012 at Sani Abacha University Teaching Hospital, Uyo, Akwa Ibom State, the claimant was diagnosed of hydrocarbon pollution substance poison attack after leaving his work location at defendant VRT hydrocarbon gas plant facility at Boni Island, River State. According to the claimant, he informed the dependent management and requested for his evacuation to a medical facility for attention at the defendant's plant clinic at Boni Island, but he was told to seek outside medical treatment for reasons that he is not the defendant's staff. employee, which necessitated his being rushed to the hospital in Uyo. The claimant was treated of occupational case of acute or chronic carbon monoxide poisoning with multiple conditions and offending kidney malfunction and pulmonary collapse. The claimant was referred for surgery and operation at the University of Calabar Teaching Hospital. After undergoing the surgery, the claimant on the 3rd day of August 2012, while undergoing further medical treatment at Emmanuel Hospital at Eket, Akwa Ibom State, was given a referral for emergency quality medical attention at University Teaching Hospital, Cincinnati, Ohio, United States of America. The claimant reported for sponsorship and assistance, but was turned down by the defendant. The claimant claiming that the claimant was not its staff, and that he is not entitled to such sponsorship or benefit, and that he is not because he is not a staff of the defendant. The claimant was flown abroad by his relatives, and he was admitted under emergency care and further diagnosed of additional 42 medical conditions of carbon monoxide poison hazard attack injuries. The claimant spent 3.5 years in USA receiving medical attention from 24th day of October 2012 to 15th day of July 2016. From the facts are disclosed by the pleadings of the claimant, it is clear to me that the proper or appropriate limitation law to govern the defendant's objection is not the federal limitation law. Rather, it is the limitation law of Akwa Ibom State and River State, as argued by the counsel for the claimant, that would govern the objection on statute of limitation. This is because the claim for salary is based on contract of employment which was entered into between the claimant and the defendant in Uyo, Akwa Ibom State in October 1996, while the injuries sustained by the personal injuries sustained by the claimant happened or occurred at the defendant gas plant at Bonny Island in River State. By the provisions of Section 16 of the limitation law of Akwa Ibom State, any claim based on contract or tort must be instituted within a period of 5 years. The question to be answered here is, has the claimant claim caught by the 5 years limitation period enforced by law to render the claimant's action on unpaid salaries, statute bar, or a stale claim? To determine this issue, the date of accrual of the action is very crucial. The law is settled that unpaid salaries falls within the category of claim of continuance of damage. This means course of action from 1996 continues till 2018, when the claimant's employment with the defendant was purportedly terminated by the defendant. This means claim for salary was not caught by statute of limitation, as the action was instituted in 2012 within the time. From 2018 to 2020, when this action was instituted, is a period of 2 years. Therefore, I found and hold that the claim for salaries was not caught by statute of limitation. For the claim or refund of expenses incurred on medical treatment and other sundry expenses, the pleading of the claimant is very clear to the effect that the claimant in April 2012, while at defendant plants at Bonny Island, River State, suffered injuries from carbon monoxide, which resulted in kidney failure and acute pulmonary collapse. Consequently, the claimant undergoes surgery at University of Calabar Teaching Hospital and attended the hospital in Uyo, Akwa Ibom State, from where he was referred to USA for emergency medical care. The request for the claimant for sponsorship of assistance to access medical care was turned down by the defendant on the grounds that the claimant is not a staff of the defendant. However, the claimant, together with his colleague, were by the Supreme Court judgment in Mobile Oil Nigeria Producing Unlimited versus Okon Johnson, reported in 2018 Nigerian Weekly Report, was declared to be employee of the defendant. However, the defendants, in its further and better affidavit, and also in its reply on points of law, insisted that the claimant is not part of the suit in Mobile Oil Nigeria Producer Limited versus Okon Johnson, reported in 2018. However, it appears the argument of counsel for the defendant on this issue seems to have glossed over the parties that were involved in that suit. It is clear that the suit was commenced at the Federal High Court in Uyo, and the claimant was represented in that by Okon Johnson. Okon Johnson and 16 others instituted the action for and on behalf of all the supernumerary police officers of the defendant, and the claimant is one of them, and his employment fall within the period for which that action was covered. In the circumstances, I overruled the objection, the claim. I disagree with the defendant that the claimant was not part of the suit Mobile Oil Producing Nigeria Limited versus Okon Johnson, reported in 2018, Nigerian Oil Report Part 1639. He is part and parcel of that suit. He is bound by whatever decision was reached by the Supreme Court in that case. For the defendant, the cause of action arose. The defendant insisted that the cause of action arose in 2001 and 2012. This means the action is statute bar for claimant cause of action respecting the refund of medical expenses is not statute bar, as the treatment was from 2012 to 2016. From 2016 to when this case was filed is less than 4 years, which means the action was filed within time. I am inclined to go with the claimant that the suit is not statute by a law. Time begins to run when there is in existence not only a person who can sue and another who can be sued, but also all facts must have happened which are materials to be proved to entitle the claimant to succeed. I cannot see how the materials to be proved to entitle claimant to succeed I cannot see how it can be imagined that the claimant could have a right to sue for entitlement respect of the alleged 2001 or 2002 accrual of cause of action when the defendant has even denied the claimant of being its employee of the defendant, and there was a litigation going on regarding the status of the claimant and his colleagues regarding their status with the defendant. The complete facts to donate cause of action to the claimant, to my mind, occurred once the claimant was declared to be staff of the claimant by the Apex Court in its decision of 20th day of April 2018 between Mobile Oil Nigeria Producer Unlimited, and Okon Johnson's and others, 2018, part 1639, page 239. It is also clear to me that the argument of counsel for the defendant seems to have overlooked or to brush aside Exhibit 1, which was attached to the counter affidavit. It is clear to me that the letter of employment says it all and is one of the considerations in the suit that culminated to the appeal at the Supreme Court, where the claimant was declared to be a staff of the defendant. It is my view, therefore, that the dependency of this case, the dependency of the case in Mobile Oil Nigeria Producer Unlimited versus Okon Johnson from the Federal High Court to Court of Appeal and Supreme Court has suspended the period of limitation to count against the claimant. In Fadare versus Attorney General of Oyo State, the Supreme Court find Namani JSC has this to say: times therefore begin to run when there is in existence a person who can sue and another who can be sued, and when all facts have on emphasis mind, which are materials to prove to entitle the plaintiff to succeed. Thus, time will start to run when all facts which constitute the plaintiff's course of action are in place. See Nigeria Port PLC, Nigerian Port Authority versus Ajobi. See also the case of Ituk and others versus NSCDC and others, 2015 LFLAR. Therefore, I'm strengthened in my view by the fact that the issue of claimant health is a matter of life and death. If claimant had abandoned seeking medical treatment to pursue a claim against the defendant when the actual cost of the treatment was not ascertained, was not feasible, Section 16 and 17 of the Limitation Law, CAF 80 of the River State, provides that no action founded on contract, tort, or any other action not specifically provided in Part 1 and 2 of the law shall be brought after the expiration of 5 years from the date the cause of action arose. The words of the limitation laws of River State are simple, clear, and unambiguous, and therefore they must be given their ordinary, natural, and grammatical meaning. See Yusuf versus Obasanjo, or reading the provisions of sections 16 and 17 of the limitation law, it is clear to me that they do not merely deny the right of action, they completely extinguish an existing right of action and action at the expiry of 5 years from accrual of the right of action. It should be noted that the duration of a course of action conferred on an injured person is limited. Tell them to own this thing. Sorry, counsel, I have to switch to another device. The device I'm using seems to be down. Yes, I'm sorry, Council. In the instant, in the case of Mobile, Sufra, the claimant and his colleagues instituted the action to know their status, to know the status of their employment with the defendant when the defendant has categorically denied claimant of being an employee. This therefore debunked the argument of counsel, the abandonment in the further affidavit in support, and also in the argument of counsel for the defendant that the claimant did not make any effort to contest or to seek for decision on the status, on his status. The case of Mobile Oil is very clear and unambiguous, and the Supreme Court has finally laid to rest that issue. The claimant in this case is an employee of the defendant. Therefore, the course of action arose from 2018. Therefore, from 2018 to 2020, when this suit was instituted, is a period of 2 years. This means that the right to commence the action is not extinguished by limitation law. In view of the foregoing, this suit was instituted by the claimant within the time. Therefore, the claimant action is not statute bar as being pending by the defendant. The limitation period was suspended by the case that was instituted by the claimant and his colleagues to determine their status before the court, because the defendant has denied being the employer of the defendant. Therefore, to my mind, the facts were not complete until after the Supreme Court has declared the claimant to be a staff of the defendant. I therefore hold that this suit, as it is presently constituted, is not statute bar. The defendant preliminary objection failed, and same is hereby dismissed for liking in merit. Ruling entered accordingly. And let me conclude now. We have to adjourn. We have to adjourn for hearing. Give me date.
No, 15 would be better. 15 is better. 15 minutes.
Sorry, my lord. The card brings up my name is right. Sorry, I have to do the question of my level at the top. That's well. No, my lord. We're going to pass it for.
Okay.
Well, my lord, for that evening.
Yes.
Well, before you virtually, what we noticed that we're not hearing you very clearly. Since our office is closed, we had to rush to answer. My lord, we are precious. Thank you so much.
My lord, she's earning you upon for the applicant. So, my lord, the very Bokora attended service, and I report to the other room.
Sorry, counsel. I had to exit the other device. Yes, this case is adjourned. It's adjourned to 15th day of March 2022 for hearing.
15.
Call the next case.
My Lord, I would like to excuse you to go and continue visually where we were, sir. Thank you, my Lord.
Yes.
Number NICN ABJ 110 2018 between Alamuto Adebayo Victor and God is Good Motors Nigeria Limited.
Any appearance? Any appearance for NICN stroke ABJ stroke 110 stroke 2018 Alamudu Adedayo Victor versus Good is God Motors Nigeria Limited. Any appearance for NICN stroke ABJ stroke 110 stroke 2018 Alamudun Adedayo Victor versus God is Good Motors Nigeria Limited. Any appearance? Any appearance? Any appearance for Alamudu Adedayo? Parties absent, no legal representation. This case is for judgment. Judgment is ready and is going to be read. This is the judgment of the court. The claimant by general form of complaint dated and filed on the 18th day of April 2018 instituted this action against the defendant, praying for the following reliefs. A declaration that the verbal termination of claimant's employment by the defendant without notice or 1 month salary in lieu of notice is unlawful and in breach of the claimant's contract of employment. B, an order of this honorable court directing the defendant to pay the sum of 50,000 naira to the claimant as the claimant monthly salary from 1st day of August till when judgment is delivered in this case. C, the sum of 500,000 naira as the money paid by the claimant to file and prosecute this case. D, post-judgment interest of 30% per annum on the judgment debt until the judgment debt is finally liquidated. The claimant testified as CW1 in proof of his case. CW1, after identifying his witness statement on oath, adapted same as his evidence in this suit. In the course of the trial, documents were tendered in evidence through CW1. The documents were admitted in evidence F1 to 3. The defendant in the course of trial, with the leave of court granted on the 12th day of November 2020, amended its statement of defense, thereby abandoning its counterclaim. One Ayodeji Adesola Michael, operating manager of the defendant, testified in proof of the defense of the defendant as DW1. DW1, after identifying his written statement on oath, adopted it as his evidence in this case. Documents were tendered in evidence through DW1 and they were marked, they were admitted in evidence and marked as exhibit DW184 and exhibit DW1B1 to 3. The case of the claimant, as can be gleaned from the pleadings, is as follows: that by the letter dated 28th day of May 2015, the claimant was employed by the defendant on a monthly salary of the sum of 80,000 naira. However, due to economic meltdown, the claimant's salary was reviewed downward to the sum of 50,000 naira. By the exhibit CWB letter dated 1st of August 2016, According to the claimant, on 26th day of July 2017, upon resumption of duty, the branch manager of the defendant informed the claimant that he has been instructed to tell the claimant to go back home, that all effort made to get the defendant to review the unjust termination of claimant's employment proved futile. The claimant stated before his employment with the defendant was verbally terminated, he was neither issued with a notice of termination of employment, nor was he paid 1 month's salary in lieu of notice. The case of the defendant on the other hand admitted that the claimant was employed by the defendant, and the defendant stated that on 26th day of July 2017, the claimant was never at any time asked to go home. The claimant, without the authorization from the branch manager, absconded his duties at work, and the defendant also stated that the claimant's employment was neither verbally terminated nor terminated at all, as alleged by the claimant. Rather, the claimant's unilateral abandonment of his employment with the defendant without giving the required 1 month's notice as contained in claimant's offer of employment. It is the case of the defendant that the claimant failure to respond to the queries served on him by the defendant, coupled with the claimant's unexplained and unapproved absence from work, the defendant by email dated 2nd day of August 2017 dismissed the claimant from service. The submission of the defendant formulated a sole issue for determination, to wit, whether the claimant, upon the available evidence or record, established a case of wrongful termination of employment against the defendant to justify his entitlement to the relief sought. I have captured the argument of counsel on the issue for determination, so I will skip reading the argument. Likewise, the claimant formulated a single issue for resolution, which is whether the defendant terminated the claimant's employment in accordance with the terms and conditions of contract of employment between the claimant and the defendant. Kinde Aino Esquire argued the sole issue. The argument of counsel has been captured in the body of the judgment, so I will skip reading the argument. In concluding, the submission counsel asked the court to grant the claims of the claimant. Court decision: I have carefully considered the pleadings, evidence laid, and the final written addresses in this case, alongside the issues formulated by the learned counsel for the parties. Having regard to the claim before the court and the defense put forward by the defendant, the issue calling for resolution is whether the claimant has proved his case to be entitled to any or all of his relief sought. The principal relief is for declaration that the verbal termination of claimant's employment by the defendant without notice or 1 month's salary in lieu of notice is unlawful and in breach of the claimant's contract of employment. The second relief is for payment of the sum of 50,000 naira as salary from 1st of August 2017 till when judgment is delivered. The third relief is for payment of 500,000 naira money paid by the claimant to his lawyer for prosecuting this case, while the fourth and last relief is 30% interest on the judgment debt till finally liquidated. The law remains right that burden of proof is always on the person who approaches the court for judicial intervention. The burden is discharged by adducing cogent, credible, and admissible evidence. Such evidence is either oral or documentary or both. At the hearing of both, bearing in mind the documentary evidence is usually prepared. See the case of Royal Nigeria Limited versus AG Sokoto State and another. It is also tried where there is an admission of material fact. The need for proof of same is dispensed with. For admitted fact need no further proof. The law is tried also well settled that claim is circumscribed by relief being sought, and the claimant is only required to adduce such evidence as will prove the relief being sought. See the case of RTB versus Cable Metal Nigeria Limited. The claimant in relief 1 is praying for declarations that the verbal termination of his employment by the defendant is unlawful and in breach of claimant's contract of employment. In proof of this relief, claimant abide upon resumption of duty on 26th day of July 2017. The branch manager of the defendant informed him that the regional manager has instructed him to ask the claimant to go back home. The claimant further stated that he made frantic effort for the decision to be reversed, but to no avail. In support of this case, the claimant relied on Exhibit CW1 to 2, CWB, CWE1 to 7, CWD, and CWE. The defendant, in response, denied ever terminating claimant's employment verbally. Rather, the position of the defendant is that the claimant absconded from duty and he was dismissed from service for gross misconduct due to refusal to reply queries issued to him. The defendant relied on Exhibit CWE and DWA 1 to 4 in support of the position of the defendant. The defendant has, in arguing the case for the defendant, contended that this court does not have jurisdiction to grant declaration in master-servant employment relationship. It also submitted that the claimant never terminated but dismissed due to failure to respond to queries. I have deeply considered all the exhibits in this suit, more particularly Exhibit CWE and DW1 to 4, which the defendant heavily relied in making the case that the claimant was not terminated. Claimant was not terminated but dismissed from service due to gross misconduct. It's clear to me that Exhibit DWA1, the purported query issued to the claimant, is a 2-page document, but only page 1 was printed and tendered by the defendant, leaving the second page. There is also no any explanation of what happened to it or why it was not tendered in evidence. The email was composed on 20th day of May 2017 at 15:18 hours, and the claimant is to answer that said query before close of business on that day. As pointed out earlier, in Exhibit DWA1, being an incomplete document has no evidential value. To make matters worse, the claimant was not given adequate opportunity to respond, and he has to respond before close of work. This has also rendered Exhibit DW1 not having weight. Exhibit DWA1 was printed on the 7th day of December 2018 at 4 a.m. For Exhibit DWA2, it is also an email, is also a 2-page document, but only page 1 was tendered before the court. This has rendered it not to have any evidential value. as an incomplete document. The exhibit also gave the claimant only 1 hour to respond to the query. This has also made exhibit DWA2 lose its evidential value as no adequate time was given to the claimant to respond. This exhibit was printed on 7th day of December 2018 at 4:27 a.m. The defendant witness statement on oath was tendered and admitted in evidence in exhibit DWB 1 to 3. The witness statement on oath DW1 is a rehash of the statement of defense. DW1 has in its evidence contained in paragraph 6, 7, 8 of the witness statement. The defendant witness statement on oath was tendered and admitted in evidence. In paragraph 6, 7, 8, witness statement on oath seems to be establishing the pleaded fact on claimant desertion and abscondment from duty without approval of branch manager, and the claimant was never asked to go back home by branch manager or verbally terminated. This piece of evidence of DW1 is hearsay and cannot prove or establish that the branch manager has not asked the claimant to go home, or that the branch manager did approve for the claimant to have his duty, to leave his duty post. The evidence of DW1 could have been reliable if he had come if it has come from the mouth of the branch manager. In the circumstances, I hold that evidence of DW1 is not having any evidential value and cannot establish anything. In paragraph 9 of the witness statement on oath, DW1 stated that the claimant's failure to respond to queries served on him by the defendant, coupled with the unexplained and unapproved absence from work, the defendant by email dated 2nd day of August 2017 dismissed the claimant from service of the defendant. This letter is exhibit CWE tendered by the claimant. The exhibit, which is an email, was shown to DW1 under evidence in chief, and he stated that exhibit CWE is the letter of dismissal of the claimant. The evidence of DW1 on the dismissal of the claimant was clumsy and incomplete. A careful perusal of exhibit CWE will clearly show that it was not a letter of dismissal of the claimant from service. Exhibit CWA clearly shows that the document was not meant for the claimant. It was addressed to partners of the defendant, and there was no evidence adduced by the defendant to show that claimant is a partner and not an employee. The tone of the exhibit CWE is to pass messages to defendant partners, informing them that the services of the claimant are no longer required by the defendant, as the claimant was involved in fraudulent act in non-checking in of ticket. The members of staff of the defendant were also urged not to relate to the claimant. It is apparent that exhibit CWE is not letter of dismissal and it never dismissed the claimant from service and never conveyed dismissal from service. Even if it will amount to dismissal, then the dismissal is with effect from 2nd day of August 2017 and not same time not in July 2017 as stated by DW1 in paragraph C of the witness statement on oath. The reason being that you cannot dismiss, terminate employment retrospectively. Termination dismissal, for it to be effective, must be with immediate effect or to take effect in a future day. DW1 contradicted himself in his pleading and evidence. In one breath, DW1 stated that the claimant was dismissed sometime in July 2017. And in another breath, he stated that the claimant was dismissed by the email of 2nd day of August 2017. From all I have been saying above, the defendant has woefully failed to prove that the claimant was dismissed from its service. In view of my finding above, I am left with the claimant evidence that the branch manager verbally terminated his employment on the 26th day of July 2017. The law frowns at verbal termination. The law requires parties to abide by the agreement and terms and conditions of service as they are the bedrock of employment dispute. See the case of Amodu versus Amodi. Exhibit CW 1 to 2 is the contract of service between the claimant and the dependent. It is clear from the letter of employment which house the terms and conditions of service that either party may, by giving one more notice or payment in lieu of notice, end the employment relationship in the case. In the case at hand, there is no evidence that one more notice was given to the claimant or payment in lieu of notice was made to the claimant. In the circumstances, the verbal termination of claimant's employment was wrongful in law. The employment under consideration being that of master and servant, the claimant will be entitled to payment of only 1 month's salary in lieu of notice. The claimant succeed in respect of relief of 1, the termination was wrongful and is entitled to damages. Or relief 2, which is for payment of salary from 1st of August 2017, this claim presupposes that the claimant is still in the service. The claimant cannot assume that his employment is still subsisting simply because it was wrongfully terminated. Employment, once terminated, it takes immediate effect, whether it was properly or wrongly done. This is because court cannot impose on employer willing employee. Secondly, claimant has not established that he worked for the period of 1st of August 2018 till judgment. On solicitor's fees, the law is settled that solicitor's fee not being part of the course of action is not granted, as same is hereby refused. The claim has heavily placed reliance on the recent decision of the Court of Appeal in Sahara Energy to make case for entitlement to damages beyond that of the notice. The defendant in oral reply to the argument submitted that where the claimant seeks for declarations that his termination was wrongful, he is only entitled to damages for the period of notice and not more. My understanding of Sahara Energy case is that where the claimant wants the court to invoke international best practices to award damages, the claimant has a duty to plead those international best practices and rely on them. In the case at hand, claimant has not in his pleading pleaded international best practices. In the case at hand, the claimant has not in his pleading pleaded international labor standard and international best practices. In the circumstances, he cannot be granted relief beyond that of the period of notice. On the whole, the claimant succeed in part, and the order of the court is as follows. 1, the verbal termination of the claimant's employment was wrongful, and claimant is entitled to payment of 1 month's salary in lieu of notice. 2, the defendant is hereby ordered to pay the claimant the sum of 50,000 naira, being 1 month's salary in lieu of notice. 3, the claimant is entitled to cost, which I assess at the sum of 500,000 naira only. The defendant is hereby ordered to pay the claimant the sum of 500,000 naira as cost of this suit. All monetary claims as contained in this suit shall be settled within 30 days, failing which interest of 10% per annum shall apply. Judgment is entered accordingly.
We God please. We are most grateful, my Lord.
Where were you? You did not announce your appearance.
My Lord, yes, I had network issue. My name is Emmanuel Adedeji for the claimant.
I have already finished. I have
Yes, my Lord.
signed my record. I have signed my record already. Thank you. You are welcome.
Thank you, my Lord.
Hard copy. Yes.
Thank you, my Lord. Yes. We are most grateful.
APJ 02 2016, repeat corporate. And 1, Minister of Aviation. 2, the Ministry of Aviation. 3, Skyway Aviation Handling Company. 4, Bureau of Public Enterprise.
Please, there is too much noise. Council should not be making noise. The court is sitting, please. There should be no noise. Any appearance? NICN stroke ABJ stroke 02 stroke 2016. Comrade Bobini Rufus versus Minister of Aviation and 2 others. Any appearance? Any appearance? Any appearance? Any appearance? NICN stroke ABJ stroke 02 stroke 2016. Comrade Bobini Rufus versus the Minister of Aviation and 2 others. Any appearance? Council, I can't hear you. Your network seems not to be good. Hello? Any appearance? I can't hear you, Council. Yes, I have seen you, but I can't hear you talk. I can't hear you. I have seen on your distance, it's written Naomi Awa, but I can't hear you. Your device must be faulty.
Can you see me? Can you hear me?
Yes.
My name is Abdullahi A. Duro.
Abdullahi A. Duro.
I appear for the 4th defendant.
Was the first defendant?
Number 4, BP, Bureau of Public Enterprises.
Okay, fourth defendant.
4th defendant, yes.
Yes, any other appearance? Any other appearance?
I know Mr. Agabi was on.
I have seen Naomi Awa raising hand. I have seen Naomi Awa raising hand, but I can't hear him. Naomi Awa is raising hand. Please talk. Yes, any other appearance? Yes, Mr. Duro.
My Lord, a short while ago, Mr. Agabi for the claimant was online. I don't know what has happened to his line, to his network.
Well, I can't see him online, but I'm seeing there is one counsel that was raising hand, and it appears he has been frozen. Has even, I think he has left. Maybe he wants to rejoin.
Can we ask for a stand down?
Yes.
Can I ask for a short stand down? I'll try to call Mr.
Okay.
Agabion. Yes, just for like 5 minutes, sir.
Okay.
Yes, sir. I will call Mr. Agabion on phone and I'll find out what's
And
happening.
okay, granted.
Thank you, sir.
Call the next case. Registrar.
Suit number NICN ABJ 57 2017 between Stephen Abua, 2 Kenneth Akalonu, 3 Paul Tefa, 4 Kendo Jonah, 5 Azaulu Oluwole, and Emerson G Resources Limited. My lord, the parties are active.
Yes, any appearance for NICM stroke ABJ stroke 57 stroke 2018 between Stephen Abo and 4 others versus Emerson G Resources Limited. Any appearance?
Yes, my lord.
Yes.
JK Akeiba initials. JK.
JK.
Yes, my lord. Akeiba is AK.
AK.
ER.
ER.
IG.
IG.
BA.
BA.
My lord, I appear with my learned friend.
Are you appearing for who?
For the claimants, my lord. All the claimants. AC Igbakwa. AC, my lord. AC initials.
AC Igbakwa.
Yes, my lord. Igbakwa is IG.
Yes.
BA.
Yes.
KUA.
Yes.
We appear, my lord, for the claimants.
Any other appearance? Any other appearance? Yes, Mr. Akiba,
Yes, my lord.
or JK Akiba.
Yes, my lord. The matter is for adoption of final written addresses.
Yes.
Parties have filed and exchanged addresses. We were, however, served with a motion, my lord, by the defendants.
Is motion, which motion? Motion for what?
It's a motion for extension of time.
Okay.
To file the addresses properly before the Honorable Court, sir.
Yes.
The motion is dated the 18th of December 2020.
Yes.
My lord, the defendants are not in court today to move the said motion, my lord.
Yes.
We want to believe they were served with a hearing notice for today's date, my lord. I'm checking.
Well, I don't know whether they have been served because there is no proof in the case file. There is no proof. Yes.
My lord, in the circumstance,
yes,
we are at a loss, but we would like to proceed to move to adopt our final written addresses, sir. In the
absence of proof of service, you want to take us back. You know the problem. If you don't have proof of service, they may come and say that they were not served and they were denied fair hearing. Why
That's
not
very
give
true,
them
my
one
lord.
more chance? Why not give them one more last chance?
My lord, sir, you know, in the event, you know, the way and manners hearing notices were served in this matter is completely in control of the registry, sir. So
but the registry, they're supposed to print and put it in my file, but there is no such evidence that they have been served. They're supposed to file the proof of service, but there is nothing in the case file to indicate that yes, they have been served.
As well in the scope. This one can as well.
That's very unfortunate, sir.
That is my predicament.
In the circumstances, we are left with no choice but to grudgingly ask my lord for a date, sir. Yeah, we have no choice. We have no choice, my lord.
A date in January for adoption. When are we having next batch first? 20th. Let me see. Which day is that?
It's a Thursday, man.
Let me see.
It is full written.
This one is the virtual.
One in front.
The remaining, all of them.
Shit.
The earliest day we can give you is 20th. January. But what you will do?
Yes, my lord.
What you will do?
Yes, my lord.
After the city, write a letter to them that the court has directed you to write to inform them that this matter came up today,
yes,
and they were not in court.
Yes, my
and
lord.
it has been adjourned to so days. They should endeavor to attend.
As God pleases, my lord. As God pleases. We are very grateful, my lord.
Okay.
I say one group by
This case is adjourned to 20th January 2021 for adoption of final written addresses. Hearing notice to be issued and served on the defendant. For the next case.
Every 257-2017 between Eheme Benjamin and Nigerian Navy.
I'm ready now.
Any appearance? Eheme Benjamin.
After this one.
Any appearance for Eheme Benjamin versus Nigerian Navy and one other?
Yes, my lord.
Yes,
my lord.
Okay. Yes.
Yes.
May it please this honorable.
Yes.
May it please this honorable court.
Yes.
My lord, can you hear me?
Yes, go ahead and announce your appearance.
Yes, my lord, I am CN Echoga, and my humble appearance is for the first and second defendants.
Yes. No appearance for the claimant. Yes, Mr. Echoga.
Yes, my lord. My lord, we were duly served with a hearing notice yesterday as regards today's matter. I recall that on the last date, my lord had adjourned the matter to today. On the last date, the claimants were absent. I had drawn my Lord's attention to the fact that we were not served with the claimant's final written address. Although my Lord had stated that he had a copy. My Lord had stated that he had a copy of the claimant's final written address in his file, and that he would instruct the registry to confirm whether or not I had been duly served, and in the circumstance that my Lord finds that I have not been served, that he will cause service of that process to be effected on me. My Lord, I am yet to receive any process from the claimant, and it seems the claimant is still absent today as well.
You see, the predicament we have is the claimant. Registrar. We have not signed up. But the council says it has not been served. Mr. Echoga. Mr. Echoga. Mr. Echoga, are you hearing me?
Yes, my Lord, I can hear you, but there's a lot of noise at the background, yes. I think from other councils.
We are in court. Council should not be making noise, please. Yes, please, I'm sorry. You know, the claimant's address was filed in Abuja. The only copy that was sent to me was the one for the court's record, for the court's case file. So I thought after the sitting, my registrar has contacted them to find out what happened to the one meant for service on you. But unfortunately, the registrar did not do that. So I'm very sorry for that. But what we should do, maybe you send your email address to my registrar, then she will now forward a copy of what we have. You certify it and send it to you so that you can make use of it. And by the next adjourned date, we proceed from there. Please, I'm sorry for that.
Very well, my Lord. It's not a problem. So I will forward my email address, but I do not know who I'm forwarding this email address to. Don't have the necessary details.
This is the final.
My Lord, sir.
Yes. Let me, hey, registrar, where is your telephone number so that he can send it to you? Call your telephone number. Write the telephone number of the registrar, please. 080 538 730 080 538 73068.
I'm so sorry, my Lord. 730
73068.
68. Thank you. Thank you.
So please text your email address to her. She will mail the address to you. So at the next agenda, we know what to do. Please, I'm sorry for the oversight. We'll adjourn it to 20th of January for the adoption.
Is that one? Let's use that one.
20th, my lord, I'm so sorry.
January.
My connection seems
20th January 20. January
Okay.
20th, 2022
Okay.
for adoption of final written address.
Very well, my lord. I'm most grateful.
You are welcome.
Thank you.
For the next case, register.
Suit number NICN ABJ 381-2017 between Chidebere Ijoma and Fidelity Bank PLC.
Any appearance for NICN stroke
Yes,
ABJ
my lord.
stroke 381 stroke 2017?
Yes, my lord.
Okay, yes.
May it please my lord?
Yes.
My name is Emmanuel T. Oji.
Yes.
My humble appearance is for
Emmanuel
the claimant.
T. Oji.
Emmanuel T. Oji. Oji is spelled as O-J-I. O-J-I.
Yes. For the
I am holding the brief of
OJI.
CS Ekeocha. I am holding the brief of CS Ekeocha.
Yes. Any
Most grateful,
appearance
my
for the defendant? Yes. Any appearance for the defendant? Yes, Mr. Oji.
Yes, my lord. The matter comes up today for adoption of final written address, my lord.
Have you filed your written address?
Yes, my lord. We have filed our written address. It was filed on the 11th day of December 2020, my lord.
(11th of December
2020, my lord.
Hello, my lord.
Yes.
With profound respect, my lord, it took honor. My humble appearance is for the defendant, Fidelity Bank PLC.
What is your name?
Etuku honor as in ETUKWU.
Etuku honor.
Yes, my lord. And my humble appearance is for the defendant.
Yes.
My lord, we have filed a
Yes. Yes, Mr. Etuku.
claimant respondent.
Yes.
Subject to the overriding convenience of the court and the fact that there is no opposition from the claimant respondent counsel, we beg to move in terms of the said motion paper to regularize our final written addresses filed on the 17th of November 2020 and our reply on points of law.
Mr. Etuku, I'm trying. I have not seen the motion, but I have your written address. I have your final written address, which was filed on 17th of November.
Yes, my lord.
2022. But
yeah,
there is no more motion for extension of time.
Well, I have a copy of the same motion for extension of time which was
When
filed on
was
the
the motion
26th,
filed?
26th January 2021, my lord.
It's not here. Where did you file it? Abuja?
We filed in Abuja, my lord.
They are yet to send it to us. I have not seen it, but I have your final written address with me. So what do we do?
If my lord will accommodate us, we can make an application orally for the said extension of time, so that we can move on, my lord.
What of the claimant? Have they filed? I have not seen their written address.
The claimant filed a written address on the 11th day of December 2020, my lord.
Okay, I have seen it. I have seen the.
Yes.
Okay, I have even seen your application. I have seen your application.
Oh, yes, my lord.
Yes, you can go ahead now.
Yes, my lord. I have lost the audio, my lord.
Recording in progress.
Mr. Oji, are you objecting? Mr. Oji, are you objecting? We lost Mr. Oji.
My lord, we are not objecting to the motion. We are not objecting.
Okay. Okay. The application granted as read.
As the court pleases, my lord, we would also beg that our own motion, our own final written address be deemed as properly filed and served, my lord.
Yes. The claimant's final written address filed on 11th of December.
Yes, sir.
It's also
Claimant's final written address, urging your lordship to dismiss this suit in its entirety.
Yes, Mr. Tuku, you can go ahead with your adoption.
We adopt our defendant's final written address and the reply on points of law, filed respectively on the 17th of November 2020 and 26th day of January 2021 as our final written addresses, in urging your lordship to dismiss this suit in its entirety.
I'm in court. Let me call you.
Mr. Oji.
Yes, my lord.
Yes, you can go ahead.
My lord, I hereby adopt the claimant's final written address as written and oral submission in this matter. We urge your lordship to grant the reliefs as stated in the statement of claim. May it please, my lord.
Let me have that there.
The audio seems lost completely.
No, there is audio. This case is adjourned to 10th of March 2022 for judgment.
As the court pleases.
I'm most grateful, my lord.
You are welcome.
I wish you a Merry Christmas and a prosperous New Year, my lord.
Thank you. Wishing you the same.
And
Thank you, my lord.
Nigeria Limited.
Yes, any appearance for NICN stroke ABJ stroke 108 stroke 2018 Musa Usman versus Regard Nigeria Limited. Any appearance? Musa Usman versus Regard. Let me see your theory. Give me, when are we having apart from that case? The next virtual after 20th. Third of. Okay. This case is adjourned to 3rd of February 2022 for adoption of final written addresses, hearing notices to be issued and served on all the parties.
Suit number NICN ABJ 293/2018 between Yahaya A. Daba and Niger State Government to Attorney General of Niger State. Hello, the passenger.
Any appearance for NICN, stroke ABJ, stroke 293, stroke 2018, Yahaya A. Garba versus Niger State Government and another.
With respect, my lord.
Yes.
My lord, my name is O.C. Uju Azoj.
Your name is?
O.C. Uju Azoj. Uju Azoj is spelled as UJU.
UJU.
Hyphen AZO ROJI.
Yes.
I announce my appearance for the claimant, and I apologize for his absence.
The greatest respect, my lord.
Yes.
CO, who is my name, my lord. Lord, I am here for all the.
Please, there is noise on the background, and it's interrupting the proceeding. Please, there should be no noise.
My lord, CO Obu. Obu. Yes, my lord. My lord, I appear for the defendants.
Yes.
My lord, the matter is listed today for adoption of final.
Please make your face available. We have to see you. Put on your camera. Please, administrator, you should mute everybody except the person talking. Yes, Mr. Uju. Mr. Uju.
My lord.
Mr. Uju. Mr. Uju. Yes, Mr. Obu, you wanted to say something.
Yes, my lord, the matter is related for adoption of address. However, we have a motion. We have a motion to regularize our statement of defense.
Okay, when was it filed?
The 18th of January. 18th of January 2021.
We have You said when was the motion filed?
Yeah, it was filed on the 18th of January 2021, my lord.
Mr. Oju, are you objecting?
Yes, my lord. My lord, we filed a counter affidavit. Yes, my lord. My lord, we are objecting because yes, the application is overreaching. It was after we filed and exchanged final written addresses that the defendant turned around due to the issues we raised in our address to file the said motion to amend their statement of defense and witness statement on oath, thereby overreaching us. We vehemently oppose the application. Our counter affidavit was filed on the 25th of January 2021, to which is attached a written address.
I don't have that counter affidavit. I don't have it.
No, we believe
You
it's
file it in
file.
Abuja?
Yes, my lord. And was before the file was moved to my lord's new jurisdiction. 25th of January 2021. It was deposed by one Uthman Issa Tochukwu.
I want to get things clear, Mr. Obu.
Yes, my lord.
Your application for extension of time.
No, my lord. My lord is not for extension of time. My lord is to amend our statement of defense and witness statement on oath to be in line with evidence already given.
No.
It's just there's a typographical error which we intended to amend, where grade 7 was written instead of grade 6. That's just the amendment, my lord. And the purpose of the amendment is to be in line with an evidence already given.
Have you been served with the counter affidavit?
Yes, my lord, we are served with the counter affidavit.
Okay, so you can go ahead and move your application.
Yes, my lord, our motion is dated the 11th of January 2021 and filed on the 28th of January 2021. My lord, the relief sought is as stated on the face of our motion paper.
Yes.
Lord, the motion is supported by 15 paragraph affidavit deposed to one Anna Audu, who is the litigation clerk of counsel to the defendant. The Lord, there are two exhibits marked A and B attached to the affidavit. The Lord, exhibit A is the amended statement of defense, and exhibit B is the proposed amended statement of defense.
Yes.
The Lord, we rely on all the paragraphs of the affidavit and the two exhibits, so and next. Also, my lord, is a written address in urging my lord to grant our application. We are most grateful, my lord.
Yes, Mr. Oji.
Yes, my lord. Mr. Uju Azoji for the claimant.
Yes, Uju, sorry. Uju.
Yes, in opposition to the application, my lord.
Yes.
We filed a counter affidavit on the 25th of January 2021.
Yes.
Was deposed to by Uthman Issa Tochukwu, litigation secretary in Festus Keyamo Chambers, solicitors to the claimant.
Yes.
With 11 paragraphs. My lord, attached to the counter affidavit is a written address.
Yes.
Which we adopt as our oral argument.
Yes.
In urging the court to dismiss the application on the ground that their application was brought in bad faith to overreach the claimant. We have made elaborate arguments here, my lord.
Yes, give me this for me. Yes.
Fine, sir. I'm an online city. Online city. Yeah, I'm doing online city.
Yes, this case is adjourned to 10th of February 2022 for ruling.
As a court, please.
Melo,
Yes.
Melo, sir, can the case that was put down be recalled, sir?
Are the counsel available now?
He is available now. I hope he won't be lost again. Mr. Agabi, can you hear us?
Yes.
Suit number NICN APJ
I can hear you, my lord.
2016 between Comrade
I can.
Rofield
I can hear you. I can hear you. Can you hear me now?
to the Ministry of
Mr.
Aviation.
Abdullahi, can you hear me?
3.
I can hear you.
Skyway Aviation
Yes.
Handling Company for Bureau of Public Enterprise. And that is part of that.
Recording in progress.
Yeah. The claimant is represented.
Yes. Any appearance?
Yes. For the claimant, my lord.
Yes.
Egan Agabi.
Egan
is E-G-A-N-G.
Egan.
E-G-A-N-G. Egan. Agabi is A-G-A-B-I.
Counsel, maybe you are using two devices. Please use only one device. Use only one device.
As the court please.
Yes.
Okay. Egan is E.
Egan who?
Agabi. Agabi.
Egan Agabi.
Yes, my lord.
Are you appearing for who?
My appearance is for the claimant.
Yes. Any other appearance?
And I appear with my learned friends, sir.
With who?
My learned friends. Our
Mention
Victor.
the name.
Our
Victor.
Victor.
Yes.
And CA, initial, CA, Makpu, M-A-K-P-U. M-A-K-P-U, Makpu.
Yes.
Our appearance is for the claimant.
The claimant.
Yes, my lord.
Yes. Any appearance for the defendants?
Yes, sir, appearance as before Abdullah Eduro for the 4th defendant. My lord.
Yes.
Abdullah Eduro for the 4th defendant.
Yes. Any other appearance? What of the appeal second and third defendants?
The third defendant has consistently, even though consistently to served hearing notices, has never appeared in this matter.
What of first and second? No appearance for first and second?
No, it appears so, sir.
Yes.
It appears so.
Yes, what is the position? So. Have you filed all your final written addresses?
Yes, yes. We have for those regular councils, we have.
Yes, Mr. Duru, have you filed your final written address? Mr. Duru, unmute yourself.
My lord, maybe I should add that he too has filed, but there is a development which I would have prayed that he addresses the cost directly. This matter has repeatedly been adjourned for settlement. It appears we are at the point of settlement, real settlement now.
Okay.
So we have given them our proposal. The claimants have given them our proposal, which they asked for short time.
Okay.
To enable them go through it. If there's anything to add or subtract, let them do. Okay. Then we present the terms before the court.
Okay.
Mr.
So let's hear from you.
Yes, my lord. My lord, my learned friend, Mr. Gabi, served me with the proposed terms of settlement. And I forwarded same to my clients, the fourth defendant.
Yes.
For their position. I'm yet to get a reply from them.
Yes.
In the circumstance that we apply for another date to enable us complete.
What of the other defendants? Are they involved in the settlement? So that you go and settle between you and the defendant and claimants, and the other defendant will come and say they are not aware.
Well, my lord,
the other defendants, are they involved in the negotiation?
My lord, Mr. Agabi may answer that,
Mr.
sir.
Agabi?
Yes, my lord. All the parties were involved, including the third defendant who has always not been coming.
Okay.
They were
so
involved.
how long do you want the adjournment to be?
I want to push that to the fourth defendant council because our proposal is with them now.
Yes, Mr. Duro, how long do you want?
Maybe the next virtual sitting in January or February.
Okay. Registrar, which one that can we accommodate them? Okay. You will come back on 3rd of February, February 3.
As the court pleases.
For report of settlement or adoption.
Very well, sir.
As the court pleases.
Very well, sir.
We're very grateful, sir.
This case is adjourned to 3rd of February 2022 for report of settlement or adoption of terms of settlement.
As a court.
So if you are able to complete all the negotiation, you can file your terms of settlement before then. When we come, we just adopt it and it will be consent judgment of the court.
As the court pleases.
We are grateful, sir.
Yes. Call the next case, registrar.
Suit number NICM-YL02-2016 between Mandis Bika Nakai and University Monument Bank Limited. I know the pastor.
Appearance, any appearance from Modis Bika Nakai versus Space City Monument Bank Limited. That is NICM/YL/02/2016. Any appearance?
Yes, my lord.
Yes.
MJ Ifegu.
NJ Ipebu.
MJ initials Ifegu, my lord. Ifegu, IFEGW.
Yes.
My appearance is for the defendant, my lord.
Was the defendant?
For the defendant, yes, my lord.
Any appearance for the claimant?
No.
Any appearance for the claimant?
I saw the claimant counsel, Mr. Olu Adebambo, online earlier. I don't know what has happened. He was present at this virtual sitting earlier.
No,
Olu
is he
Adebambo.
not? He's online.
Yes, my lord.
Him. But you
Yes,
have to
my
show
lord.
your appearance on your camera, please.
Yes, my lord.
If you
J.
want me to
Olu
record you,
Adebambo.
you must on your camera if you want me to record you. You must on your camera if you want to be recorded. Yes.
J. Olu Adebambo. J is the initial. Olu
Are you
Adebambo.
appearing for whom?
For the claimant, my lord, also appearing with me is KB Batodo. KB Batodo.
KB Balogun.
KB Batodo, B-A-T-H-O-D-O.
Batodu. Yes. Yes, Mr. Ipebu.
Yes, my lord.
What is the position?
Have you had the motion, my
Lord,
lord?
the matter is for adoption.
Yes, are you ready?
My lord, the matter is for adoption.
I said, are you ready?
Adoption of written
Have you
addresses. However, we have the motion and notice before the court to regularize our written address, my lord.
When was the application filed?
And the motion of notice is dated 7th July 2020. And filed the same day, my lord.
Yes.
My lord, we are ready to move the motion subject to the compliments of the court.
Please go ahead. Because
My lord,
it appears
our
the
motion-
place where you are, your service is no good.
My lord, can you hear me, my lord?
Yes.
Yes, our motion is dated 7th July 2020.
Go
and
ahead,
it's
go ahead.
brought pursuant to order 57 rule 4 of the rules of this honorable court.
My lord, we are not opposing the motion.
Okay.
Yes. Hello, since the counsel to the defender is not opposed to the motion, we want to humbly move in terms of the motion paper, my lord. And we urge the court to grant our application as prayed.
Application granted as prayed.
As copy, please.
Yes.
As copy. Thank you. Thank you very much, my lord.
Yes.
My lord, our final written address, defendant's final written address.
The what?
Was the defendant's final written address was filed 16th March 2020. March 2020. Dated 16th March 2025, 16th March 2020. Yes. We respectfully adopt them as our oral submission in this suit. I will urge this honorable court to dismiss the claims of the claimants. Yes. We are grateful, my lord.
Yes. Mr. Adebambo.
My lord, the claimant's final written address is dated 7th July 2020. And filed on the same day, my lord.
Yes. Yes.
And the claimant has formulated one issue therein for determination.
Yes.
We want to humbly adopt the written address as our oral submission.
Yes.
An argument in support of the claimant's claim. And we urge the court to grant all the claims of the claimant as contained in his writ of summons or particulars of complaint.
Yes.
We are most grateful to your lordship. Thank you very much, my lord.
Okay. This case is adjourned to 14th day of March 2022 for judgment.
As
God please, my lord. We are most grateful to your lordship.
We are obliged, my lord.
Thank you very much, my lord. Merry Christmas and Happy New Year in advance, my lord.
You are welcome. Thank you. We wish you the same.
Suit number NICN ABJ 301/2017 between Mr. Augustine Okerimpa and one Economic and Financial Crime Commission EFCC. 2 Ibrahim acting chairman.
14. Thank you very much, sir.
Yes. Any appearance?
Yes, my lord. Lord, I appear for the claimant. My name is Uday Fuku, 80 initials.
Yes, any other appearance?
Yes, my
Yes,
lord.
my lord, I appear with my friend Naba Frank.
Inaba.
Frank. Yes, is double NABA.
Yes, I know.
As company,
Yes.
my lord, we have our humble appearance for the claimant.
You are appearing for the
claimant.
Okay.
Yes, my lord.
Whom are you appearing for?
I'm appearing for the claimant. The claimant.
What of Inaba?
I'm appearing with Inaba. We are appearing. Yes, appearing is my junior.
Where is he? Where is he?
He's here.
Yes.
With profound humility to this honorable court, S.A.
Yes.
Ugwebulam is my name.
S.A.
Ugwebulam is spelled U-G-W-U-E-G-B-U-L-A-M. My appearance is for the defendants.
Yes.
For the defendants, yes, my lord.
Yes. What is the position?
My lord, the matter is slated for adoption of final written addresses.
Yes,
However,
have you filed?
We have a motion to regularize. We have filed our written address. We filed out of time. So we have a motion to regularize it.
To regularize our owners.
Once there's regularizer.
When was the application filed?
My lord, it was filed yesterday, 15th of December, 2021.
Have you served it on the other party?
Yes, my lord, we have.
Have you served it on Mr. Udechukwu?
Yes, my lord. Yes.
Are you objecting?
No, I'm not objecting, my lord.
Application granted as read.
As the court pleases. Thank you, my lord.
Yes.
My lord, I think the course is clear for us to proceed to adopt our final written addresses.
Yes.
Yes, we have before the court.
Go ahead.
Yes, my lord. We have a final written address dated 1st of December 2021 and filed on the 2nd of December 2021.
Yes.
My lord, we seek to adopt it as our argument in support of our defense. And we urge the court to dismiss the claimant's case for being baseless, vexatious, and misconceived. The claimant is a servant who cannot be imposed on the master. Thank you, my lord.
Yes.
You know,
yes, Mr. Udechukwu.
Yes, Lord, we filed a final written address dated 19th day of this November 2021, was filed on 1st December 2021.
Yes.
Lord, we wish to adopt on behalf of claimants.
Yes.
Lord, we graciously ask our Lord to all the needs sought by the claimants.
Yes. Yes.
Yes, Lord.
Yes.
We urge your Lordship. Yes, my Lord. You know, the case of the claimant.
Yes.
A nutshell of the case of the claimant is that the claimant was wrongfully employment was wrongfully terminated. Yes, my Lord.
Yes.
Lord, community reading of the entire pleadings, including the documentary evidence standard and evidence given before your
Yes.
Lordship. Lord,
Yes.
the claimant was not given opportunity to defend the allegation against him.
Yes.
Yes, my Lord. Lord, the defendants claim that there was a committee set up to look at the claimant's conduct. My Lord,
Yes.
there's no evidence before you that the claimant was even invited to that committee. None. Huh? Yes. Beloved,
yes.
It is well understood that in matters of this nature, that is partial judicial in nature, that all parties must necessarily be given fair hearing.
Yes.
Beloved, the argument that the employment has no statutory pleasure may not stand.
Yes.
Beloved, even in the written address of the defendants,
yes,
4.08, paragraph 4.08,
yes,
the defendants made a very lame attempt to suggest their lordship that they follow due process of law.
Yes. Yes, Mr. Udechu.
Meanwhile, that the relationship is a mere master-servant relationship, and that they can will throw away a servant through the window without any recourse.
Yes.
Lord, we urge your lordship to know that the defendants play God.
Yes.
Might against a weak employee, and that is the purpose why the government have been sure that are not treated.
Yes.
Now, yes, most of the advocates to stand for this.
Let me have the diary. This case is adjourned to 14th of March 2022 for judgment.
As a couple, please. What
You are
did
welcome,
match?
Council. Thank you
Thank
very
you, my
much,
lord.
Council. We have come to the end of the virtual sitting. The administrator will end the sitting. Thank you very much for your cooperation.
Thank you, my lord. Have a Merry Christmas.
Same to you. I wish
Thank
you all
you.
the best.
Thank you, my lord.
Okay.